My name is Orla Lynskey. I'm an assistant professor of law at the London School of Economics, and my primary areas of research expertise are in data protection and privacy law. However, in the past I worked in competition law practice for a couple of years, and so I'm also interested in the intersection between data protection and competition policy. And today what I will present is a paper that was published in 2017 in the Common Market Law Review on the intersections between data protection and competition law. I've also added a couple of insights that I've been thinking about since then in order to bring this presentation up to date and up to speed. So I'm going to make 3 claims in this presentation. The first is that there is normative coherence and material overlap between data protection and data protection and competition policy. And what I mean by that is that in certain circumstances, data protection policy and competition policy pursue similar goals. In particular, their concern for the welfare of the consumer, albeit that they operate at different levels at different levels in terms of how they are enforced. Then following on from that, I'm going to claim that data protection can have an influence on competition law in 2 ways. First of all, it can have an influence in terms of being an internal influence on competition law. By that I mean that competition law internalizes data protection assessments. So data protection is taken into account as an element of consumer welfare by competition authorities. I'll explain that more as we go along. The next way in which competition and data protection intersect is when data protection constitutes an external influence on competition assessments. That means, for instance, that data protection may prevent a competition authority from imposing a remedy that it may otherwise consider desirable in particular circumstances. And so I will elaborate more in this presentation on the way in which data protection can constitute both an internal and an external influence on competition policy. So, as I mentioned, data protection and competition policy, although distinct, clearly, could be looked at as pursuing some shared or common objectives. So in terms of material overlap, there are clearly large areas where the two do not overlap at all. So for instance, if you're looking at a transaction that involves the merger of a swimming pool with a company that is providing other leisure facilities, then clearly data protection is of no relevance to that competitive assessment and as to whether or not it will be cleared as a transaction. However, there are ways in which data protection can become relevant to competitive assessments. The first thing I would say here is that it's necessary to keep in mind that there is a critical distinction between, on the one hand, data protection and, on the other hand, privacy. While the two are often considered to be synonymous, or data protection is viewed as a subset of privacy, I and many others have argued in privacy and data protection scholarship that in fact data protection is in some ways broader in scope than the right to privacy. For instance, data protection can systematically apply to the processing of public data, whereas in privacy we might query whether or not there's a reasonable expectation that certain data is private. And so there's a difference in scope, but there may also be a difference in terms of the rights granted under a particular framework. So data protection is often something that is legislated for through data protection regulation. And if I take the recent example of the GDPR, General Data Protection Regulation in Europe, you could see there, for instance, that gives individuals the right to data portability. Now that is traditionally not a right that we would associate with privacy. However, it is coherent or consistent with the objectives of data protection law, which is to give individuals more control over their personal data. So with that background in mind, I think it's necessary to highlight that data protection can form part of competitive assessments when looking at, first of all, the legal context for market definition. So here there might be a query about, for instance, whether or not data could, and personal data in particular, could constitute, if aggregated, a barrier to entry to a particular market. And or whether, for instance, data once aggregated could become a source of market power. And so in that sense, looking at data like any other resource, it could be looked at as relevant from a market definition perspective. However, I think it's also possible to argue that data protection can be internalised by competition law if we view data protection and the level of data protection offered to individuals as a parameter on which firms can compete. And I'll elaborate on that a little bit later on. More broadly speaking, data protection and competition law can share some common objectives. For instance, in the EU context, or if we look at something like the OECD privacy principles, you see that one concern there is for the free flow of data. And so there's an aim that data protection regulation should facilitate market integration. Both data protection and competition law, as I've mentioned, share a concern for the individual. Data protection law is concerned about the individual as citizen, whereas competition law is concerned about the general consumer welfare of the individual. And both data protection and competition law, at different levels, can act as a counterweight to power asymmetries. So if you look at the data protection framework, you'll see, for instance, that it's an information forcing framework. It contains rights of information for individuals, and therefore it seeks to remedy or rebalance certain information asymmetries and power asymmetries between individuals and those who process their personal information. Similarly, you might say that provisions like abuse of dominance provisions are there to counterbalance positions of market power and to ensure that negative consequences, negative economic consequences of that market power are not experienced by individuals. So in that sense, there is some substantive coherence between the two policies. As I said, I'm going to argue that data protection can be both an internal constraint on competition law and an external constraint. Just to explain a little further what I mean there. When I say an internal constraint, I mean that data protection is considered as an aspect of consumer welfare. Now, consumer welfare or enhanced consumer welfare means that consumers get lower price, higher quality, more innovative products with more choice on a particular market. Here you could say that data protection could influence in two ways. First of all, if you conceive of personal data as the price that you pay or as the consideration in contractual terms for access, for instance, to a free product or service, then you might see competition between firms on the amount of data, the quantity of data that they gather and the variety of data that they process, and that could be likened to price. I think there are some problems with that perspective, and therefore I think a better way of internalising data protection into competition law is through the parameter of quality. And here we would consider that in certain markets, for instance, markets involving services online or content online, which is free at the point of access, and where customers don't therefore, or individual users of those sites don't therefore provide any consideration or monetary payment to access the content or service. Those services are free. That means price competition is effectively eliminated, and therefore quality competition becomes a lot more important. And here what I would suggest is that one dimension of that quality competition is competition on the basis of the data use and data protection conditions offered to individuals. So that's when competition law incorporates data protection. And so competition authorities are not in those circumstances acting as data protection authorities. They're acting perfectly within their own remit. It just so happens that the substantive criteria for both data protection and competition laws overlap. Competition law can then exercise, or rather data protection can exercise an external constraint on competition law in some other circumstances. That could happen in several scenarios. For instance, it could be argued that in the merger context, as I will suggest later on, even if a transaction is cleared because it will not lead to any significant impediment to effective competition or anything similar, we might have a parallel non-competition assessment of that merger to see what its impact is on data protection. And we have that type of non-competition assessment in, for instance, the case of some media mergers to assess the impact of the transaction on media plurality. And so there you can see that data protection, or the external factor, is having an external influence on competition law. So the same can be said for data protection, I would suggest. Then just to elaborate a little bit more on this idea of internal constraint. As I said, we are not here suggesting, and we were not in our paper suggesting, that competition authorities should breach the principle of legality by seeking to use their powers in order to enforce data protection laws. Rather, our claim was that when all of the constituent elements of a competitive infringement are present, or for a competitive assessment are present. So for instance, in the context of abuse of dominance, you have defined the market, there is a position of dominance and there is a subsequent abuse, then that can incorporate potential data protection considerations. So the competition law conditions must be fulfilled before data protection can be internalized in this way. And then the next step in our reasoning is that data protection law can be used to help inform competition authorities as to how they would assess whether, for instance, a particular transaction or particular market behaviour would lead to an improvement or a deterioration in the quality of data protection offered to individuals. So in that sense, we refer to data protection law as a normative anchor that competition law can be hooked onto in order to make a particular competitive assessment. Now, competition authorities do this, for instance, in the context of intellectual property, where they might, in the context of an examination of a potential abuse of dominance, look to intellectual property law in order to help to determine what a fair, reasonable and non-discriminatory price may be for certain intellectual property, or to determine what the correct limits or the desirable limits for in terms of the length of a particular intellectual property protection might be. And so in that sense, competition law does often hook onto other areas of substantive law in order to inform the competitive assessment of competition authorities. So how might this be relevant from a practical perspective in competition law? Well, if we recognise data protection law as a normative benchmark, we could say that, for instance, we would have competition between competitors on the basis of data protection or privacy. Now, this was implicitly recognised by the European Commission in the Facebook WhatsApp transaction and was more explicitly recognised by the Commission in the Microsoft LinkedIn concentration or merger. And in those circumstances, the Commission acknowledged that undertakings might compete on the level of data protection that they offered to individuals. You can also see that outside of the merger context, you might conceive of different ways in which data protection might be of relevance to competition authorities. For instance, in the ongoing German Competition Authority or Bundeskartellamt investigation into Facebook's data processing practices, you can see that from the publicly available documents, it appears that the claim being made is that Facebook is dominant in a market for social networking services, and that it is using that dominant position in order to extract excessive quantities or unreasonable quantities of personal data from individuals. And so that seems to be a type of exploitation claim. What is interesting about that investigation is that that investigation could similarly be undertaken by a data protection authority. Indeed, Facebook is currently being investigated by several data protection authorities across Europe. Does that make the Bundeskartellamt's investigation illegitimate? We would argue not, because the conditions for competition law are fulfilled. There has been a market definition, there has been a finding that, or at least an allegation that Facebook is dominant in the relevant market, and then there's an investigation as to whether or not its practices are abusive. And so in that way you can see that that these regulatory and legal frameworks, so the regulatory framework for data protection and the legal framework for competition law, can and do overlap. Equally, we could think of something like a predatory data protection policy or predatory privacy, where you might say that until a service acquires a critical mass of users, it offers a relatively high level of data protection standards, and then once it has consolidated or once it has gained a position of market power, it then decreases the level of data protection or privacy offered to individuals, knowing that there are fewer alternatives or no alternatives available for them at that point. So an analogy there with predatory pricing. Equally, you might think of certain agreements to restrict competition on the level of data protection offered to individuals. So many of all of the competition infringements that we can think of in terms of concentration, abusive dominance, and then potentially restrictive agreements could all be conceptualized in a way that involves data protection considerations. There are some challenges here, particularly if we think of trying to inform how competition authorities would assess whether or not a particular transaction or particular market practices have a negative impact or will lead to the deterioration of data protection provisions or the quality of data protection offered to users. One thing I think it's necessary to state at the beginning is that one might query why in a regulated area a competition authority would investigate the level of data protection offered to individuals. Here, I would suggest that we could consider cases like the European Commission's Deutsche Telekom case, where the Commission considered that even in a regulated sphere, if the market participants have a certain amount of wiggle room or leeway, they can use that leeway in ways that are more or less beneficial to competition. So equally, I would say here that the data protection principles offer a minimum threshold that that data controllers or undertakings that are processing or controlling the use of personal data must respect. But that doesn't mean that we can't build on that. And as such, you can see divergence in terms of the quality of data protection offered to individuals. Indeed, that was something that the European Commission noted in the Facebook-WhatsApp transaction. Facebook and WhatsApp offered different levels of privacy and data protection to their users. So the discretion in the regulatory framework does leave scope for competition. Then the question is, does a transaction or market behaviour have an impact on that level of competition? And here, while from a constitutional perspective, for instance, there is significant divergence globally about the status afforded to the right to privacy and equally the right to data protection, What we can see is that over 100 countries worldwide have adopted data protection legislation, and that legislation tends to converge around a core set of data privacy principles. And these data privacy principles can be witnessed, for instance, going back to 1974 in the US Federal Privacy Act. You see the Fair Information Practice Principles. In the OECD Privacy Principles, they're there. In Convention number 108, which is a Council of Europe convention, you see them there. And in the EU Data Protection Rules, you see them there. And those data protection rules have served as a blueprint elsewhere. So actually, despite widespread divergence in terms of the constitutional status of these rights, in terms of the minimum standards and core principles, we actually have quite a lot of convergence. And I would suggest that convergence can be used as a starting point in order to pinpoint the factors that competition authorities could take into consideration when assessing the impact of a transaction on the quality of data protection offered to individuals. Now, in the same way that competition authorities might enlist the assistance of economists in, for instance, determining the potential impact of a transaction on price, I would suggest that a competition authority might be able to enlist the help of a data protection authority and privacy regulators in order to help determine what the impact of a potential transaction is on data protection and privacy. And in this way, data protection can be internalised within the competitive assessments. A further challenge and a further way in which competition authorities might internalise and do internalise data protection and privacy rules is through their assessment of the regulatory backdrop or the legal landscape in which a particular transaction takes place. So no transaction occurs in abstract conditions. It's always grounded in the particular legal and economic framework of the jurisdiction under consideration. And so here, data protection will form part of that regulatory and legal landscape against which a competition authority must make its assessment. And here I have noted a number of things. So first of all, there tends to be the assumption that because data protection and data-driven markets, or markets involving personal data, are regulated by data protection legislation, that any privacy issues that arise are a matter for data protection or privacy law, which seems like a reasonable assumption. However, if we look at a transaction like Facebook's acquisition of WhatsApp, we can see there that, for instance, the European Commission notes that Facebook and WhatsApp differ in terms of the privacy protection offered to individuals. However, they consider that the two are not close competitors for reasons including the fact that there is multi-homing in this market, so consumers might have various consumer communication apps on a single device, but also because of their differing privacy policies. And so here the Commission, in essence, implies that competition on the basis of data protection is not a significant or a key parameter of competition between Facebook and WhatsApp. What I would suggest in those circumstances is that we need a more detailed understanding of the ways in which consumer decision-making is functioning in these markets. And here, I think it's possible that we have what Farrell labelled in an excellent 2012 paper, a dysfunctional equilibrium, and that dysfunctional equilibrium persists despite regulation. So I'm going to move to the next slide so you can see what I'm talking about here. So if we start at the top of this slide, you might say that there are several factors that influence consumer decision-making when it comes to how their personal data are being processed. For instance, you might have convoluted boilerplate terms. So privacy and data protection policies are infamously long, and they are also quite complex with very little if any, prospect to negotiate them in a tailored way. We also have the idea of bounded rationality, which might be that individuals are only able to process or only taking into consideration the shorter term implications of data processing rather than anything that might be on the longer term horizon, including whether or not the morsels of data that they are providing in a disaggregated way can subsequently be aggregated in order to infer very insightful conclusions from that data. There's also a significant number of decisions required by virtue of the fact that individuals increasingly engage on the internet through mobile devices and in other ways. And we have a complicating factor here of secondary markets and personal data, which might not even be visible to individuals. As a result of all of these factors, I would suggest, there is a pervasive sense of a loss of control that is evident in many empirical studies conducted on when individuals are asked about how they feel about the processing of their personal data and whether they feel to be in control of that processing. But critically here, what Farrell suggests might be the outcome of that pervasive sense of loss of control is that individuals resign themselves to the idea that irrespective of their actions, they will not be able to have privacy or data protection. As a result, you can see at the bottom of the slide, Farrell suggests that there is then a lack of incentive for firms to compete on the basis of privacy and data protection, because there is no reward for those offering good terms. And this then in turn feeds back into this vicious circle by leading to a further deterioration in data privacy quality. So this piece was written by Farrell in 2012. And I think it is interesting to note that the extensive empirical work conducted by Which, a consumer protection organisation in the UK, in 2018, so published on the 5th of June 2018, confirms what it calls rational disempowerment, which is very similar to this dysfunctional equilibrium suggested by Farrell. And the idea behind rational disempowerment is not that we need to understand consumer biases or anything else, so it's not necessarily a behavioural economics approach. It is saying the rational way for consumer to behave in these markets is in fact to give up on privacy in this context. And so I think that's something that competition authorities need to be cognizant of when, for instance, stating that there is no market for data protection competition in a particular context, as was the implication in Facebook WhatsApp. It is entirely possible that the reason there wasn't more competition on this basis is because of this dysfunctional equilibrium. Equally, Amelia Fletcher and many others have suggested that demand-side interventions might not be sufficient in making these types of markets work effectively for individuals. So we need to understand the more structural problems or more structural factors that are influencing consumer decision-making, so the systemic issues. And here, I think a few things could be relevant to competition authorities. For instance, you might think that under the General Data Protection Regulation, because firms have taken the regulation relatively seriously, we have seen since the 25th of May 2018, its entry into force, that some firms are offering different business models or options to consumers based on whether or not they want more or less data protection or privacy. So for instance, you could have access to this platform for free if you're willing to accept data processing and targeted advertising. You might have access for a certain subscription fee or micropayment if you wish to have no personal data collection or processing. And as a result, we could see competition. So competition on the basis of data protection is clearly then emerging, but also this makes it more, makes it slightly easier, in fact, to put a price on data protection. I won't go into the potential normative implications of that here because they're very significant, but from a competition authority's perspective, it therefore matters whether or not data protection regulation is working effectively or ineffectively. It will have an influence on how these factors emerge in a competitive assessment. So for instance, if a price does emerge for data protection, then when a data protection authority assesses whether or not an individual is being asked to give too much data, or in the words of general data protection regulation, data that is unnecessary for the purposes of the performance of a contract, then a data protection regulator will effectively become a price regulator. That again changes the landscape, the legal landscape for competition authorities, because if data protection becomes a de facto form of price regulation, then this puts even more pressure on the qualitative dimensions of product and service competition. So I would suggest that it is becoming increasingly difficult for competition authorities to simply state that data protection and privacy concerns are a matter for data protection and privacy law. In some ways, it is necessary to look under the hood and to see how those laws are being applied on the ground and what the lived experience of consumers are in terms of their interactions in data-driven markets, because otherwise there's the risk that relevant factors will be overlooked in any particular competitive assessment. This slide here was simply to illustrate, and this slide can be credited to Privacy Matters, a data protection and privacy specialist consultancy based in the UK. But here you can see, and I won't go into this in any detail, but simply an example of the complexity of the terms and conditions that were offered to individuals after the Facebook acquisition of WhatsApp, when asked to determine whether or not they consented to have their WhatsApp data aggregated with their Facebook data. And so you can see that there were several steps that were necessary in order to complete this process, and that in order to opt out effectively, you needed to go to the second stage of the WhatsApp privacy policy. So the strong hint, the strong nudge on the first step of the privacy policy is on the left-hand side under the mobile app TOS update. And you can see that if you wanted to change the default settings, and we'll be aware that the consumers have strong default inertia, you needed to go to that second stage and then change the default settings and still click agree. So this was by no means a straightforward exercise for consumers. And so from a policy perspective, rather than a purely legal perspective, you might say that by also a further effect of disregarding privacy at the point of, for instance, a merger transaction, is that this puts the data protection framework, which is already under considerable strain, under even more pressure, and puts even more pressure back on individual users to be informed and active and engaged in terms of how their personal information are used. And that then, while seemingly a reasonable requirement, hits back to all of the issues that I mentioned when I was speaking about this dysfunctional equilibrium that seems to persist in many of these data-driven markets. So competition policy is inadvertently putting even more pressure on data protection and privacy policy. And this links then to my next point, which is that sometimes data protection can act as an external constraint or a form of overriding requirement in the context of competition law assessments. And here I'm going to speak about this from a purely EU perspective, because I do think this depends to a large extent on the constitutional or primary law status of data protection or privacy in a particular legal system. But if you look at the EU legal order, you'll see that data protection is granted primary law status in an EU Charter of Fundamental Rights and also in the EU treaties. And those fundamental rights and that treaty basis mean that the European Commission cannot ignore data protection when applying competition law, insofar as competition procedures must respect data protection in the same way that they must respect the right to an effective remedy, for example. But there are also queries here about whether or not a competition decision, which as formally adopted is an act of an EU institution, the European Commission, could impose a remedy or accept a commitment from undertakings that itself breaches data protection law or even challenges its effectiveness. And here I think there was a good example of this in that came before the French Competition Authority in a Gaz de France case, where, and you could imagine this in several other scenarios, if a former state monopolist, as was the case in the French case, has historic access to a database about consumers, including insights into its customers' preferences, then competitors in a liberalised market might want access to that data in order not to be put at a competitive disadvantage when it comes to competing on a liberalised market. But clearly granting access to that database, if it could be shown to be an essential facility, would then itself be potentially problematic from a data protection perspective. And so here you could see that a competition authority, even though its desired remedy might be granting access to particular data, that remedy might conflict with data protection rules. And so here you see the need for cooperation, as was the case in France and as occurred, between data protection and competition authorities. Equally, in EU law, we've seen that at times the application of treaty provisions on competition law have been disapplied if there is an overriding external policy goal that a particular activity serves. So the classic example here might be the Wouters case. So in those ways, data protection can act as an external constraint on competition policy. Finally, I do think this might be most relevant in the merger context, and that is because we might argue that irrespective of individual decision-making, or if we see a continued market failure in markets involving personal data, then we might say that competition authorities do not need or cannot accurately factor in data protection as part of their internal competitive assessment, and yet data protection and privacy have fundamental right or public good dimensions, depending on the legal system in question. Why do I say data privacy could have a public good dimension? Well, I suggest that because it's not something that the market will necessarily provide for unless incentivized in some way to do so. It's something that individuals may or may not care to pay for, or may or may not care to take actions to defend. However, the lack of it on a widespread basis can raise significant public policy issues. So in that way, you might consider data protection you might compare data protection to something like environmental pollution. Equally, if it's conceived of as a fundamental right, then it serves collective as well as individual interests, and that's the case in the EU legal order. And so there, we could argue that in the context of data-driven mergers, where irrespective of whether or not they are deemed to raise competitive concerns, there might be a separate non-competition assessment to consider the impact of the transaction on data protection concerns. So if we look at a lot of merger activity in data-driven markets in recent years, we can see that the merging parties are not necessarily in any way actual or potential competitors. So in fact, one of the driving forces for these transactions, it would appear, at least externally, is the data in question. So for instance, if a platform, and I'll take here the example of Google, acquires a smart home device like a smart thermostat, that allows Google, in addition to the data it collects on its own platforms, to also collect data from inside the home. If Facebook acquires, or when Facebook acquired WhatsApp, that enabled Facebook to potentially access the phone numbers of users which it might not otherwise have had. Equally, we've seen several transactions in the healthcare sector where these forms of data that might not otherwise be available to big platforms are being made available through acquisition. And so, but this might not raise competitive problems, because as long as there is sufficient competition on markets for instance, data analytics, then this won't be looked at as a competitive issue. However, that data aggregation, because not simply of the volume of data that's collected, but also the variety of data, might lead to superior insights being gained into the behaviour, the thinking of individuals, what interests them, what their future interests could be. And as such, those types of transactions can raise data protection and privacy concerns. And it's for that reason that I would propose that we would see a non-competition assessment of this type of transaction. And here we have the precedent in the media plurality context. So if we see, for instance, a merger of two significant newspapers, then in some jurisdictions, a non-competition assessment is conducted alongside the competition assessment in order to determine whether or not post-merger there will be a significant variety and reach of media and newspaper coverage in a particular functioning democracy. And so here I would say that we have a similar motivation. Data protection can be looked at as an end in itself, but it's also instrumental to many other valuable public goods. So for instance, from an economic perspective, we could say that data aggregation and those superior insights can facilitate price discrimination or quality discrimination, where different individuals are offered the same product at different prices. That might be economically efficient, but it might be looked at as unfair. And so in that economic context, it can be problematic. But equally, it could be problematic in the context of political micro-targeting, as we've seen over the past few months, I guess most evidently in the context of ongoing investigations of Cambridge Analytica. And so data protection here is not simply about preserving individual rights to be left alone. It is about ensuring that there is a robust framework for the processing and subsequent use of personal information, and that robust framework is not undermined through artificial aggregations, or potentially undermined through artificial aggregations of data in the merger context. And so in that way, we could investigate whether or not data protection acts as an external constraint on competition assessments. So again, it would not be for competition lawyers to make this assessment, because the claim would be open there that would be going beyond their expertise and would be potentially undemocratic or would lead to subjectivity. Here, you could have an external body, and that could be a parliamentary committee, thereby removing the potential critique that this is undemocratic, or it could be an expert agency. So at European level, you could think of something like the newly created European Data Protection Board, providing this type of advice in this type of context. So in conclusion, suggested here, as initially proposed in a 2017 paper co-authored with Dr. Francisco Costa Cabral, that data protection can exercise an internal constraint on competition law, and that's when it respects the internal logic of competition law and forms part of the consumer welfare assessment. But equally, it might form an external constraint on competition law, and that's where it has a normative influence on competition law by potentially excluding competition law or influencing the remedies suggested by competition law in a particular way. And finally, before I conclude, I would suggest that if you're interested in these issues, the August 2018 edition of International Data Privacy Law, so that's International Data Privacy Law, an OUP journal, will focus exclusively on this intersection between data protection, competition and consumer protection law, and contains a wide variety of contributions on this matter. Thank you.